Very briefly, I'll tell you a little bit about the background of the Chungs. Jin and Sue Chung were born and married in Seoul, South Korea. They worked very hard and lived a blue-collar lifestyle, essentially, in Seoul. Mr. Chung worked in a charcoal factory. Mrs. Chung worked in a dress shop and was also a homemaker. In 1992, they did what a lot of our ancestors looked to do, which is to come to the United States and try to experience the American dream. They wanted to start their own business, and they wanted to own a home. So in 1992, they came to the United States. Upon arrival, had the intention of working hard and saving so that they could potentially buy their own dry cleaner. Mr. Chung worked in a dry cleaner in the back as an hourly wage laborer, working the laundry machines. Mrs. Chung worked in a seamstress factory in suburban Virginia, in Annandale, Virginia, kind of Little Seoul of sorts, in Annandale, Virginia. They worked hard, and over those 5 years, they saved up enough money so that in 1997, they could open that first dry cleaner. They opened a very small store in Northwest Washington, kind of in a bad neighborhood, but a neighborhood that they thought could thrive and a neighborhood that would utilize their services. That store, fortunately, because of their hard work, did thrive. And in 2000, and then successively in 2006, they were able to open 2 more stores. So in 14 short years of being in the United States, as a result of hard work, the Chungs had really gotten to achieve that American dream. They were owning their own business, and they had been fortunate enough to buy their own house. Little did they know, however, that a mere year later, they would be facing the American litigation nightmare instead of that American dream. And that nightmare was at the hands, unfortunately, of a judge, Judge Roy Pearson. So flash forward to, okay, what is this case about? That's the Chungs. The case was basically in relation to, related to the D.C. Consumer Protection Act. And what Consumer Protection Acts do is they forbid merchants from misleading consumers in certain ways. But many Consumer Protection Acts, like the D.C. Consumer Protection Act, is incredibly vague. It really doesn't provide very definitive proof requirements, which we'll get to in a little bit, which allows plaintiffs like Roy Pearson to be able to really pretty much for any reason sue any small business or large business if that were the case. So what was the case about? Mr. Pearson was in 2005 about to be hired as an administrative law judge, and he was previously before that unemployed. And during his unemployment, he had evidently gained a little bit of weight. So he decided, in anticipation of his new job, that he would take his pants into custom cleaners to have them altered, basically have the waist let out a little bit. Brought a series of pairs of pants to the cleaners. The custom cleaners very diligently altered the pants and returned them to them, but there was one pair of pants in particular, now the $54 million pair of pants, that was brought in early May 2005. My clients misplaced them for a very short period of time. Mr. Pearson, I think for a number of reasons, none of which related to my clients, at that point was an angry person. He was recently bitterly divorced. He was very financially strapped and also had a lot of time on his hands. And so when my clients eventually produced what we can prove are his pair of pants to him, he was so angered that he wouldn't accept them. Flashing forward as a result, he initially brought a lawsuit under D.C. Consumer Protection Act for $50,000, claiming that my clients misled him, both as to the identity of his pair of pants, first of all, and also misled him in relation to a sign that was in their store. The sign in their store said "Satisfaction Guaranteed." This is where you get to the Consumer Protection Act misleading element. He argued that that "Satisfaction Guaranteed" sign gave an unconditional guarantee of satisfaction to the customers of custom cleaners. So, as a result, according to his theory, if Mr. Pearson came into custom cleaners and said, "I'm not going to be satisfied, Jen and Sue Chung, unless you give me $54 million, and they did not give him that $54 million, that his satisfaction was not, in fact, guaranteed, and as a result, that sign was misleading. That was the theory of the case. It sounds absolutely, and is in fact absolutely ludicrous, But the problem is that the D.C. Consumer Protection Act is so broadly cast that, in fact, someone smart, representing themselves like Judge Ward Pearson, can exploit it and ultimately destroy the lives of a small business in Washington, D.C. What was the result? I think we all know from the news that the Chungs did win at trial. The case is currently being appealed, but the Chungs won at trial, but importantly, the Chungs won nothing, as they mentioned. The Chungs had to close their store as a result of the case due to flagging revenues and also the diversion of time to this case from their store. So they won nothing. And I'm confident that we're going to win on appeal, and if we don't ever hire me as your lawyer. But if I'm confident we're going to win on appeal, but again, even if we win on appeal, ultimately the Chungs have won nothing. The Chungs have been the big losers, unfortunately, in this case. And to wrap up with Mr. Pearson, he likewise not only lost a trial, but he also, I think everybody knows, lost his job as well. So he's no longer a judge, and so we're not at his mercy anymore, but unfortunately the justice system still is, based on the fact that the appeal is being filed and in fact will probably be heard sometime in mid-November of this year. But let's get to Consumer Protection Acts. And if you'll indulge me, let's talk about how this case can come to be. Consumer Protection Acts were born out of two things. First of all, the Federal Trade Commission Act. The Federal Trade Commission Act was created in order to stop largely big corporations from deceptive trade acts, essentially. And whenever these large corporations would, to the extent that the Federal Trade Commission believed, engage in some sort of misleading activity, the Federal Trade Commission could tell those large corporations to stop doing what they're doing. Well, following from that, states in the 1970s or so started enacting Consumer Protection Acts. And what Consumer Protection Acts did was to give individual consumers, so the rank and file citizen like us, gave them the opportunity to sue, and to sue for money damages to the extent that they believed that a merchant had misled them. The important thing is, though, that these Consumer Protection Acts had very few proof requirements, if at all. The body of law, and if we could bring up the slide very quickly. The body of law that Consumer Protection Acts are derived from is something called common law fraud, or fraudulent misrepresentation. And as you can see, and is intuitive, fraudulent misrepresentation requires the proving of four actually elements in order to establish that fraud had occurred. A false statement. So, for example, if the obvious example, if you're a car dealer and for some reason you decide to falsely allege that a car that you're selling has in fact not been in any sort of car accident, you would, as a car dealer, you could be sued under common law fraud under the allegation that you made a false statement by saying that to the consumer that the car had not been in fact involved in an accident. The car dealer, or under common law fraud, you also had to have an intent to deceive. Obviously, it makes sense. You need to have intent in order to be liable for anything, either criminally or civilly. You also had to have the consumer rely on the statement that was made by the car dealer. So the person buying the car had to rely on what the car dealer was telling them with respect to the accident history of the car. And then, of course, you had to have actual harm. You have to actually have bought the car, and as a result of purchasing that car, be harmed with regard to problems that you had with the car, or whatever the case may be. Well, so that makes sense. And it makes sense that in order to recover money damages, you should have to prove all of those elements. But unfortunately, in Consumer Protection Acts, there are very few proof requirements, if any at all, in some states. In most states, all that's required is the proof of a statement that has a tendency to mislead, which is much different than, as you can see on number 1, the proof of a false statement.